let's get started. And to kick us off, I would like to offer a land acknowledgement. So I honor Mother Earth and Father Sky, the mineral world, the plant world, the animal world, the human world, our ancestors and their wisdom, our responsibilities as future ancestors. I honor the land on which I stand, which is the unceded territory of the Awaswas-speaking Yupi tribe. The Amamutsun tribal band, comprised of the descendants of indigenous people taken to Mission Santa Cruz and San Juan Bautista during Spanish colonization of the Central Coast, is today working hard to restore traditional stewardship practices on these lands and heal from historical trauma. I honor all you beautiful beings in this room. Thank you for caring. Thank you for healing. Thank you for dreaming with us. And thank you for believing in the more beautiful and just world we know is possible. My name is Shenshen Wu. I'm the founder of Wu Projects, which is a container for art, research, and permaculture projects aiming to make a positive change in the world. I was introduced to the Terran Collective last June and immediately sensed our values alignment. Not long after that, I began contributing to Hilo, an open source software application they steward, and our collaboration continues to this day. I'm honored to be co-hosting this event with them. Tibet, could you please introduce yourself and say a few words about Terran Collective?
Sure, yeah, thank you, Shenshen. My name is Tibet Sprague. I'm here on unceded Chochenyo Ohlone territory, known by many, known to many as the Berkeley Hills, Berkeley, California. And yeah, really excited and honored to be co-hosting this event. Thank you so much for organizing, Shenshen, and to Thomas for being here and sharing your knowledge and wisdom with us. Yeah, the Terran Collective is a community of care and practice that is working on building systems and tools that foster trust and collaboration in service to a more regenerative future. And we're really just trying to figure out how humans can cooperate better with each other and with the planet. And we have a very bioregional focus because we think we can have the most impact on the land that we are living on and in the communities that we live with. So here in the Bay Area, we do a lot of community building, community weaving here. We think about kind of how do we create new systems of economic systems and systems of decision making that are more just and equitable and in right relationship with each other and the land. And as Shenshen mentioned, we're also working on a software platform called Hilo to kind of be the infrastructure for this type of collaboration and cooperation with each other. And yeah, I think I will leave it at that and pass it back to Shenshen. Thanks again.
Thank you, Tibet. Next up, I'd like to introduce Thomas Linzey, who will be leading the training today. Thank you, Thomas.
Thank you, Shenshen.
Yeah, it's great to have you here. Thomas serves as a senior counsel for the Center for Democratic and Environmental Rights. He is the co-founder of the Community Environmental Legal Defense Fund, CELDEF, and is widely recognized as the founder of the contemporary community rights movement, which has resulted in the adoption of several hundred municipal laws across the United States. He's also the co-founder of the Daniel Pennock Democracy School, which assists groups to create new community campaigns, which elevate their rights over rights claimed by corporations. He's licensed to practice law in Pennsylvania. He's written numerous books, and his work has been featured in many well-known publications and recognized by many awards. I could really go on. There's a lot to say about Thomas, but I'll let him take it away.
Great, thanks Shenshen. And big thanks to the collective and to the Wu Project, and especially Shenshen for setting this up. I think we have about a couple hundred emails between us to get this set up. So I know at the outset, everybody is probably tired of looking at a screen. And I know I fall into that category as well. We try to make this as exciting as possible and talk for about 30 minutes or so about the rights of nature. I think the good thing is that the subject material lends itself to a degree of excitement. It's probably the most exciting stuff I've worked on in the past 25 years, this concept of rights of nature. So what are we talking about today? Well, we're talking about human civil rights type protections for nature. And that in itself kind of bends our brains sometimes, because we're used to talking about human civil rights. We're used to talking about the US Constitution and the Bill of Rights, and we're used to talking about our state constitutional Bill of Rights. So we're used to talking about rights for people. But what we're talking about today and the work that's been happening over the past 15 years in the United States and elsewhere is really about recognizing human civil rights type protections for nature. So think rights for forests, think rights for rivers, think rights for coral reefs, conversation we just had with some Hawaii folks that want to take this concept and apply it to coral reefs in Hawaii. And of course, it goes without saying, but to say it anyway, that we wouldn't be talking about rights of nature if we had an existing environmental regulatory system that was actually working. So if we had a system of environmental protection in the United States that was actually functioning to protect the environment, we wouldn't be talking about human civil rights type protections for nature. We wouldn't be talking about this rights of nature concept. And I also don't think I have to remind folks of how bad it's gotten in the US and elsewhere. But we have some statistics that we throw out at the beginning of these talks, such as the fact that in the United States, 4 billion pounds of toxic chemicals are released into the atmosphere annually. That's just the United States. So 4 billion pounds of toxic chemicals. That there are now 80,000 industrial chemicals currently in use in the United States. And in each of our bodies, we can now detect 700 or more of those industrial chemicals. So 80,000 industrial chemicals currently in use. And if you test your own body, you will find 700 or more traces of those 700 or more chemicals found within every human body. Half of all plant and animal species have now been driven to extinction. So half of all plant and animal species. 90% of all original forests have been logged in the United States. And most surprisingly, I think perhaps the folks that have come of age during the Clean Water Act and these federal national environmental laws, that 40% of all of our waterways, our rivers or tributaries or creeks, still failed to meet even the most minimum clean water standards that we have set in the Federal Clean Water Act, namely that waterways are fishable and swimmable. That 40% of all waterways still fail to meet those standards within the United States, even after the passage of these federal environmental laws. So sometimes what we say is that, 40 years after the major environmental laws are passed in the United States, the environmental situation in this country is worse now by almost every major environmental statistic than they were 40 years ago before those federal environmental laws were passed. So something is seriously wrong, and this doesn't even talk about the elephant in the room, which is climate change, which is a game changer for everything. But those are some of the statistics and kind of the vantage point through which rights of nature is being talked about, that these systems of environmental regulations and permit appeals and all that kind of stuff have failed us and failed us miserably. We are in a situation much worse than we were in 40 years ago in many ways. So how do people, why is this relevant? Why are we talking about rights of nature? How do people come to this path? How do people come to this realization? What do they do about it? Well, we came to this path because for 10 years, I attempted to enforce conventional federal environmental law. I was the guy that was bringing lawsuits under the Clean Water Act and the Clean Air Act and the National Environmental Policy Act with my prior organization, which was known as CELDEF, or the Community Environmental Legal Defense Fund. And for about 10 years, that's what I did, was permit appeals, basically trying to enforce federal environmental laws, state environmental laws. And most of what environmental law consists of today, conventional environmental law, is environmental lawyers being retained by community organizations that don't want certain things to come into those communities. And for us, it was about 100 communities across the state of Pennsylvania, which is where I went to law school. So rural communities in the state of Pennsylvania who are facing a 20,000 head hog factory farm coming into their community, or a toxic waste incinerator, or a toxic waste landfill. something that the community didn't want because of the harms that those projects pose to those communities. And the day that we live, which I lovingly refer back to as Groundhog Day, in case anybody's seen the movie Groundhog Day with Bill Murray, in which he lives the same day over and over and over again. Our work was kind of like Groundhog Day. We would live the same day over and over and over again. It would all start with a phone call from a community that didn't want one of these projects. We would then begin work, and the work that we did then is the same as environmental lawyers do now, which is they sit at a desk and they take the application, permit application from a corporation that's been submitted to put something in, and they compare it against the environmental regulations that are in place at the state level that dictate what needs to be in the permit application for it to be issued. And generally, environmental lawyers come in at the bottom of the ninth in baseball parlance, which is the corporation has already applied for a permit, the state has already issued the permit, and the community then walked into our door asking, how do we overturn this permit? But basically, all that stuff had happened already. And the work of conventional environmental lawyers is to go in and try to find gaps, omissions, and deficiencies within the permit application submitted by the corporation to argue to a court that the permit never should have issued, that the permit was issued in error, that it was a mistake, that somebody overlooked something. So we spent days arguing in front of judges about signature lines or about bond amounts or about stuff that was missing from a particular paragraph that had to be there. So our arguments to a judge were, Your Honor, under section 523, little I, little c, little I, little Roman numeral 2, little e, little 2, little c, little d, that there was a signature missing on page 59. And therefore, the permit should never have been issued. It was issued in error. You need to overturn it, Your Honor. And those are the types of arguments that we would make in front of judges for about 10 years. And we would win most of those. We would win most of the first round kind of challenges, precisely because we showed up. 90% of permits that are issued in the United States are never challenged today, mostly because the communities lack the resources. A lot of these projects go into minority communities, African-American communities, indigenous communities, don't necessarily have the resources to engage in a long-term challenge to these kinds of permits that are being issued. So sometimes the battle, as I learned growing up, was just showing up and arguing to a judge and doing the work and those types of things. So what would happen next? Well, I think a lot of folks on this call know what happens next, which is the corporation, after the permit was overturned, the corporation 3 months, 6 months later would simply return, this time with a new and improved permit application. And then the permit application would get approved, and then we would be back in the defensive position that we had found ourselves in the first place trying to fight these. And I'm shortening this story down just for purposes of this webinar. Some of these went through 10, 12, 15 rounds. We had a fight with Walmart that went through a bunch of different years. But the most ridiculous thing about how this permit appeal process works, and there's plenty of ridiculous things about it, but just to pull out a couple. One is that we had law firms, some of the biggest law firms in the country that represent these large corporations, come up to me after the arguments in front of the judge and thank us for finding these gaps, omissions, and deficiencies in the permit applications, because then those law firms could charge more hours to the corporation to work to fill in those gaps, omissions, and deficiencies within those permit applications. And the second thing that struck me about this whole process was that at least we thought we were forcing the companies to pay money to their lawyers to come in. We were at least causing some kind of pain or soul searching on behalf of those companies. But then we learned the fact that the monies that the corporations spend defending their permits issuances against us are tax deductible under the tax code as a reasonable and necessary business expense for the corporations when they have to come into court to defend those permit issuances. Certainly wasn't tax deductible for the communities that we were representing, but it is tax deductible for the companies to defend their permit issuances against communities that don't want those particular projects in those communities. And so somebody said something to me around that time, very smart person, smarter than we were, that has stayed with me since, which is, she said, the only thing environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists, because the regulations make us predictable as to how we fight the project when the project comes into the community or wants to come into the community. And the, you know, kind of the well-known fact that we don't say often because we don't want to admit it to ourselves, but the environmental regulations are generally written by the very industries that ostensibly those regulations are intended to regulate. So I worked in the Capitol in Pennsylvania for a couple of years, and I saw the agribusiness industry write bills and write regulations. It's not us in the room when those regulations are being written. And if we think the companies are going to provide anything in those regulations for us to use to actually stop the projects that they're proposing, we're the crazy ones. Insanity is the kind of, you know, definition of insanity is trying to do the same thing over and over again. For 40 years, we've tried to make this system work. And in almost always, it hasn't worked. It's worked for some, hasn't worked for us, which is why the natural environment is in the state that it's in. So a lot of folks at this point say, you know, so what, right? We have the system that we have. It's environmental laws, it's regulations. We can file permit appeals. We can become experts on how much liquid manure can be spread per acre, and then get engaged in these regulatory fights and have arguments over poop and how it can be applied and where it can be applied. Or we can start deciding ourselves to do something different, not following a script that's been written for us by someone else, but instead doing our own thing with what, not asking the question of what can we get under the existing system of law, which is what that's the question that most community groups ask, is what can we get under the existing system of law? But what do we need? What do we need to protect the natural environment? What do we need to protect our communities? And so we went through some soul searching back in the early 2000s and started re-examining the very foundation of environmental law. And the essence of environmental law, the essence of law in Western society, is that in the US, we have a European system of law. And that European system of law that we have in the United States basically treats nature as a dead thing, as dead, as inanimate. Forests exist for us to use it for timber. We call plots of land that don't have houses on them undeveloped, even though the ecosystems on those pieces of land have been developed for millions of years. We have a view in this Western system of law that nature is a dead thing, that it's a thing. It's not capable of having rights. It's not capable of any kind of treatment other than being a thing, but it's dead, it's inanimate. Now contrast that to the indigenous, to indigenous visions. And I never like to lump all these together, but to try to talk about the indigenous vision as kind of a guiding star here in terms of not talking about nature as a thing that can be owned, but as a relative, as a living entity. And so, you know, the Ponca Nation in Oklahoma talks about the need for the tribe to speak for those without voices, i.e. rivers and forests and mountains. The White Earth Chippewa in Minnesota talk about the flying people and the swimming people and the singing people. So being alive, being part, being connected. The Yurok Nation in California, which recently recognized the Klamath River as having rights, passed this law, which one of the laws that we're going to talk about nature having rights, talks about the Klamath River as being a relative, a living relative, a living being. So contrast those indigenous views with this European system of law that we have, this conventional system of law in the United States, in which nature is dead and inanimate. And I think the best way to explain it right off the cuff, Sir Francis Bacon, an English philosopher, he once said that the whole purpose of Western civilization was to, quote, torture nature on a rack to extract her secrets. So that's the quote. Torture nature on a rack to extract her secrets. And for folks that aren't familiar with, of course, medieval times, the rack was used to stretch people until they separated, till the bones separated from the joints. So that's the kind of violent way in which the Western system of law essentially sees nature. From a legal perspective, because nature is a thing under the system of law, the constitutional structure that we have, which protects property rights almost all above almost all other values. And if you go to the Constitution, you won't see the word nature. You don't see the word environment. It's not in there. You see property and commerce, because it was written in the 1780s. It's what people knew. They didn't know about acidification of the oceans, didn't know about deforestation, didn't know about climate change. They knew about property and commerce. That's what the constitutional stuff, the source code for this country has in it. And because of that, because nature is a thing, you can only protect it to the extent that it doesn't interfere with property values. because that's the core element in the constitutional stuff. So it should come as no surprise, perhaps, that our environmental laws, whenever they run up against that property rights piece, are usually defeated. You have court decisions that overturn environmental regulations, for example, for being takings of property under the system of law. So all to say, just to put a pin in that for a moment, that the US Constitution protects certain things, doesn't necessarily protect nature, and nature is kind of subordinate to that constitutional structure of property and commerce. So again, people say, well, so what? We have this Western system of law, we got to work within it. We can't do anything else other than that. Of course, our indigenous clients and communities say different things than that. But if you're in a white, Western community, the question is, so what? This is the system that we have. What do we do? Well, we went searching for a different system. And it turns out that indigenous communities have, of course, had this value system tens of thousands of years. In Western law, it only recently emerged in the 1970s. And so in 1972, there was a professor named Christopher Stone from University of Southern California. He had a law class that he was trying to wake up one day, and he introduced the concept of nature having rights. That instead of doing this environmental law, which is predicated on property rights and permit appeals and all that kind of stuff, he asked his law class the question of, what if trees had standing? What if trees had standing to access courts? Because under the US system of law that we have, this judicial system of law, you can only go into court if you've been injured. And so when we're trying to protect nature, the inquiry of law, the legal question is, have you as a person, as a human being, been injured by the harm that's being done to this forest, this mountain, or this river? That's the question that's asked in court. And that's a very limiting question, because it looks at our exploitation or our use of the natural resource and doesn't look at nature itself being harmed. So why is this important? Why is Christopher Stone important? Well, Christopher Stone wrote a law review article called Should Trees Have Standing? And usually law review articles, I've written a couple as well, usually just sit on shelves and gather dust because nobody bothers to read them. Well, Christopher Stone's did not, because at the time he wrote the law review article, there was a proposal by the Walt Disney Company to put in a major development in California, in the Sierra Nevada mountains, a big ski resort. So this is 1972. Walt Disney Company wants to put a ski resort in Mineral King Valley, which is east of San Francisco on the border with Nevada. It's now the Sequoia National Park in that area. But see, the Walt Disney Company wanted to put in a development that was bigger than Disneyland. That's usually all we need to say. It was bigger than Disneyland. That's the kind of scope for this thing. And a lot of people didn't want it. And so the Sierra Club ended up suing. So the Sierra Club brought a lawsuit to stop the development. And the lower courts dismissed the Sierra Club lawsuit on the basis that none of the Sierra Club members had standing to bring the case, because they weren't impacted by the development. The land may have been impacted by the development, and the area was impacted by the development. But again, the legal inquiry on standing is, have you been impacted by the development as a person? And the courts use this standing concept to throw environmental groups out of courts all the time. And this was one of those examples. Sierra Club got dismissed from the case, went up to the US Supreme Court. Name of the case, not too important right now to remember, but Sierra Club versus Morton. That was the name of the case. Goes to the US Supreme Court, and the US Supreme Court dismisses the case. No surprise there, right? On standing issues, US Supreme Court has been one of the worst on standing issues. They dismissed the case. The only thing that made this case different, the only reason why we're talking about it today, is that Justice William O. Douglas, probably one of the most progressive US Supreme Court justices ever, took Christopher Stone's law review article and made it into a dissenting opinion. So a formal dissent to the dismissal of the Sierra Club by the US Supreme Court. And in that dissenting opinion, Justice Douglas raised for the first time, Justice William O. Douglas raised for the first time, this concept of nature having rights within a Western kind of construct of law. And just to read a quote from his dissenting opinion before we move on, he wrote, "Contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own preservation. This lawsuit would therefore be more properly labeled as Mineral King versus Morton, not Sierra Club versus Morton, but Mineral King Valley, the actual natural asset, if we want to use that term. But the place in nature where this was going to take place should have been the plaintiff, not the Sierra Club. So that was kind of a high point in 1972. This decision, Sierra Club versus Morton, the emergence of this law review article, people started talking about this material, at least nature having access to the courts. So what happened next? The answer is nothing happened next. Zero. The dissenting opinion came out. Nothing happened except some people talking about it, but nothing real happened for close to 40 years. And what happened in 2006 changes the story's arc, which is that we had a client in Pennsylvania, a municipality called Tamaqua Borough. It's a community of about 7,000 people northwest of Philadelphia. And in that borough, small rural borough, town, for folks that don't live in Pennsylvania, a town in Pennsylvania, that there was a plan by the governor of Pennsylvania to haul PCB-laden dredge from the Delaware River and dump it into the borough of Tamaqua. The borough of Tamaqua was a big coal mining center at one point. They have all these open mine pits. And so the governor of Pennsylvania decided that this would be a good place for when they dredge the Delaware River and they pull up all the polychlorinated biphenyls, PCBs, in that bottom of the riverbed, that they have to put it somewhere and dispose it. So what they wanted to do was truck it into this little place called Tamaqua Borough. Needless to say, the people of Tamaqua Borough didn't want to be a toilet for PCB-laden dredge coming in from the Delaware River. And so they enlisted us to help them draft a local law that, in essence, recognized that the people of Tamaqua had a right to clean air and clean water, a legally enforceable right to clean air and clean water, that this project threatened to violate those rights within the community, and therefore that the community banned the waste from coming into the community. As a municipality, they said to themselves, and they took a vote, and they passed a law. And the law said we have a legally enforceable right to clean air and clean water, and we're going to ban this waste from coming in. Tamaqua is important because it's one of the drinking water sources for Philadelphia via the Little Schuylkill River, which flows through the township, or the borough of Tamaqua. And so at that time, we also were trying to understand this rights of nature stuff, this standing stuff. It never went anywhere after the dissenting opinion was written in 1972. And we talked to Tamaqua Borough Council members and the environmental group there about perhaps doing something new, taking this concept of rights of nature and actually driving it into a local, legally enforceable ordinance, a law. Not just talking about it. We've all been to conferences where people say we love nature, I love nature, we all love nature, but it doesn't get us anywhere because nature is not recognized within the law at this point. Rights of nature are not recognized outside of the places where this stuff has touched ground. Tamaqua Borough is one such place. We talked to them about protecting the rivers and the tributaries within the borough, or within Tamaqua Borough, by recognizing that those rivers had the right to exist, flourish, and naturally evolve. So legally enforceable standards that were written into this particular law in Tamaqua. And the laws that you see now are really progeny of that first place, that Tamaqua Borough, that little courageous place that decided to make a stand against this waste and to recognize the rights of nature, that the ordinance there, the law that emerged in Tamaqua Borough, had three commonalities with all of the laws that have come since. One is they recognized legally enforceable rights. This wasn't a resolution that said, wouldn't it be nice if rivers had rights? This was actually legally establishing those rights. Secondly, it said anyone could sue to enforce those rights by stepping into the shoes of those rivers. So the Little Schuylkill River could be a plaintiff. And again, this bends our brains as well, but that the river itself would be a plaintiff. And finally, the damages that the remedies afforded if you won the lawsuit on behalf of the river was restoration to the pre-damaged state of the river. So provided for damages, in other words, a remedy of restoration in Tamaqua Borough. Tamaqua Borough, with the passage of that law, which I think amazed everyone, became the first government in the world to adopt a rights of nature law, a law which recognized legally enforceable rights of nature. And just to show you how small the world is, the next thing that happened about a year after Tamaqua Borough, that law passed, is we got a call from Ecuador, country of Ecuador, where they had a constitutional assembly that had been assembled, to actually write a new constitution. And they had read about what happened in Tamaqua Borough. So Tamaqua Borough made the news. They had news clippings from Tamaqua Borough, and they wanted our help in taking the rights of nature materials and actually writing it into the new Ecuadorian constitution. So we flew down, met with the Constituent Assembly, told the story of some of these communities, including Tamaqua Borough, that had been playing around with these rights of nature material, and assisted them to draft the language. That language became part of the new Ecuadorian constitution. It was ratified overwhelmingly by the people of Ecuador, first country in the world to embed rights of nature into their constitutional construct. So national constitution, rights of nature, provisions into the Ecuadorian constitution. Since then, there have been over 60 enforcement cases using that rights of nature, those rights of nature provisions within the Ecuadorian constitution. The first case was a case called Vilcabamba River versus Province of Loja. Not important to remember the name of it, but all to say that a river was the plaintiff in the first case brought to enforce those constitutional provisions within the country of Ecuador. So the way that this has worked over the years is that the Ecuadorians went first on the constitutional stage, international stage. Then it boomeranged back to the US. We were contacted by the city of Pittsburgh. Pittsburgh City Council said to us, look, we have a proposal for fracking. It's hydrofracking for natural gas, which has become very controversial in the US and abroad. And we wanted to do a ban on fracking within the city of Pittsburgh. Just to give a little color here, there was a plan by an oil and gas company to drill under a Catholic cemetery within the center of the city of Pittsburgh. They had signed a lease with the diocese to actually access oil and gas underneath grandma and grandpa in the Catholic cemetery in the middle of the city of Pittsburgh. Didn't make the oil and gas extraction companies very popular. City Council wanted to draft a law that not only banned fracking, but protected the three rivers, the Ohio, the Allegheny, and the Monongahela within the city of Pittsburgh with these rights of nature protections. To our amazement, the Pittsburgh City Council unanimously adopted that law, which was a ban on fracking in addition to the protection of the rivers. Since then, about 36 communities across the United States have adopted these rights of nature laws. City of Pittsburgh, probably the most popular. A lot of people know Pittsburgh. There have been counties as well that have passed rights of nature laws, but about 36 municipal communities have passed these laws across the US. And then something even more surprising happened, which was that all of these had traveled so far via legislative enactments. So people drafting a law, passing a law in a governmental setting, and then that law being enforced. But what started to happen next kind of sped up this whole process, which is courts in other countries began adopting rights of nature by saying that rights of nature was an emerging international precedent of environmental law, a new emerging norm of environmental law in the world. And that was enough for them to start taking rights of nature concepts and using them for rulings by those courts. So we're talking about the Colombian Constitutional Court, which in 2016 ruled that the Atrato River had rights. So one of the main rivers running through Colombia, not because they had a law in the books, but because the judges pulled this from other places and decided to apply it as jurisprudence, as a legal rule without having a law in place. In 2017, a court in India held that the Ganges River had certain rights. In 2018, the Colombian Supreme Court ruled that the Amazon and the Amazon River Basin had certain rights. And in 2019, the High Court of Bangladesh ruled that all rivers within the country had certain rights. So think, slow going in the beginning through these legislative enactments. Things have picked up speed now through these courts adopting this wholesale, even without laws in place. In addition to those international courts, there's been movement by tribes across the US as well. So in 2015, the first tribe, the Ho-Chunk tribe in Wisconsin, took a vote on adding rights of nature to their constitution for the Ho-Chunk tribe. The Ponca in Oklahoma, the Ojibwe, the Chippewa, White Earth Nation in Minnesota adopted a rights of nature law with our help protecting wild rice, Monoman. So this cultural staple wild rice, recognizing a right of a plant species. So rights of nature, but applied to a plant species. The Menominee tribe in Wisconsin protected recently the Menominee River, with a legal enactment recognizing that the river has rights. The Yurok tribe in California recognizing the Klamath River as having rights. And most recently, just about a couple months ago, the Nez Perce in Idaho recognizing that the Snake River has rights. So there's been this huge kind of expansion on the indigenous level through these tribal enactments. Tribes have their own constitutions. Tribes also have their own tribal regulations and laws that rights of nature can be implemented into. So two last things before I shut up and we open it up for questions and discussion. But so the 15 years ago, talking about rights of nature was enough to put you in a padded room, right? People wanted to put you in a padded room to talk when you were talking about rights of nature. I did a tour across the country with a South African lawyer. We had people walking out of the room when we mentioned the concept of legally enforceable rights of nature. Law professors storming out. Not so much the students, good sign, but the law professors, other people who have built careers around environmental law, storming out of the room. That doesn't happen anymore. People don't storm out of the room anymore, but it's still kind of not mainstream yet. It's still on that fringe, but it's getting there. So law schools have now held conferences, symposia on rights of nature. We partner with Tulane Law School to do the first one. Vermont Law School has done one. Levin College of Law in Gainesville, Florida, also did one with our partner group, the Florida Rights of Nature Network. Believe it or not, the Democratic Party of Florida has put rights of nature into their party platform. So the Democratic Party of Florida putting rights of nature into the party platform in the state. The Democratic National Committee back in 2016 actually had a rights of nature plank in their national party platform, the DNC. They refused to do so this year, but in 2016 they had one which was related to indigenous sovereignty rights and using rights of nature to enhance those sovereignty rights. The Orlando Sentinel, a major newspaper, endorsing a rights of nature law that moved locally there. League of Women Voters as well. Something that we probably wouldn't have seen 10 or 15 years ago. And finally, to finish out, I just wanted to talk about Florida. I know we have quite a few people here whose names I recognize from Florida. And I think Florida is a good spotlight to kind of end with my presentation, at least here, which is that folks that are familiar with Florida know that they're in a water crisis. That it's a water crisis of things like red tide and algae blooms over the years. Dead sea life. When I was there last, they were picking up dead sea life off the beaches with backhoes and putting dead sea life by the ton. We're talking manatees and dolphins, into trucks to take them to landfills. So dead sea life. It's really a crisis there when a place like Biscayne Bay, which is in the southeastern corner of Florida, goes to zero dissolved oxygen levels, zero. And we don't need to be biologists or chemists to understand that zero is probably a really bad thing, because unless you have oxygen in the water column, no life survives. So they had this huge fish kill, basically declared the Biscayne Bay as dead, that it was dead, it died. It had zero dissolved oxygen levels in it. So with that and with other problems across the state, the Caloosahatchee River, Lake Okeechobee, the Army Corps of Engineers releasing contaminants out that go down the waterways to either coast, that folks in one place, Orange County, Florida, which is where Orlando is, a county of 1.4 million people, 30th largest county in the United States, came together and drafted a Right to Clean Water initiative, which not only established people's right to clean water within that county, which was a first for Florida, also most of the United States, but also established that the Wekiva and Econlockhatchee rivers and other waters within Orange County had the rights to exist, flow, be free from pollution, and maintain healthy ecosystems. So we're talking about standalone rights within this Orange County law. And I think to most people's amazement, people in Florida can't agree on anything. You just need to look at the latest presidential election results to understand that. But apparently they can agree on one thing, which is clean water and the necessity of clean water and protecting ecosystems that provide that clean water. And I think to a lot of people's amazement, it passed by 89% of the vote. Nothing passes by 89% of the vote anymore. Indeed, if it ever did, 89% of the vote in Orange County. That work gave birth to a group called the Florida Rights of Nature Network, which is now working in other places across Florida to replicate what happened in Florida in Orange County around the passage of this law, this what's known as a charter amendment. They amended their local county constitution, which is known as a charter, and in fact had a county commissioner run entirely on the platform of this initiative, and she beat an incumbent and is now a county commissioner in Orange County, who is advocating and has advocated for the rights of nature there. So with that, just one quick other thing, which is that we're kind of, the Center for Democratic and Environmental Rights is kind of the go-to place for communities across the US, including tribal communities that come to us and ask for help in drafting materials and moving it forward through the tribal context. But you know, we're kind of the go-to for drafting. We're the go-to for advice on how to do this work, how to move stuff forward at the municipal level in cities, towns, counties. We're working at the state level now in a couple of places to move state stuff forward along the rights of nature route. And we also recently launched a campaign team, which is a separate 501c4 corporation that does political work that can help communities with messaging, petition preparation, campaigning, phone banks, basically the whole gamut of things that people need to get this stuff off the ground, because it looks daunting sometimes to think about doing this at the local level. So the question is, how do we provide those support platforms to communities that want to move forward at the municipal level to pass these kinds of laws? So that's the spiel.
Amazing. Yeah, thank you. Thank you so much for sharing that wealth of information and for your knowledge. It's so fascinating to kind of hear about how things have changed, you know, in your time working in this area. And it's inspiring. It really gives me hope and a lot of fire to, you know, get these laws passed, get nature protected. So we have a few minutes here now where I'd like to open up the floor for questions. I see some people have their hands raised, so you can go ahead and use that feature, or you can type your question in the chat as well. So I know that Shay Howell has had her hand up. Shay, would you like to ask your question?
Sure, thank you. I have more than one. Should I choose just one or try to wrap them all into a single overarching question?
Let's do one for now, just in the interest of time. And then towards the end, I'd like to share a little bit about possibilities for us all to keep in touch and keep on with this momentum.
Okay, thank you. My knowledge gap here lies in sussing out the difference between what are the rights of natural systems versus what are the rights of living systems. I've heard both terms, and I'm assuming that living systems mean sentient or animate beings, whereas natural systems are what you were just discussing, like rivers and air. Is that correct?
Yeah, I've never really heard that distinction before. That's new to me. But we talk about natural systems, we talk about ecosystems. We don't usually use the word living, just because when these rights of rivers laws are passed, they protect the river as a whole, the watershed, the banks, you know, the water itself in the column. So I've never heard that distinction before, I guess is what I'm saying.
All right, thank you, Shay. I see now Zach Day has his hand raised. Zach, would you like to ask a question?
I would, thanks, Jen. Tom, thanks for being here. Really grateful to be here with you in person to hear this message live. I rewatched the recording from your presentation at the Bioneers Conference, which kind of put this topic on my radar. So my question is, I'm sorry, but I'm wrapping two into one. First, how do we prevent political encoding from becoming intertwined into this topic so that this does not become a left or a right issue? Because obviously if we, you know, I feel like once that happens, it limits our ability to have effective fact-based discourse on, you know, regarding this topic. And then, and maybe we're going to talk about this organically as a part of this conversation, but what can we do to start building momentum locally where we live? I want to start reaching out to some city county councilors and trying to put this topic on their radar, try to organize a meeting with you, with whoever else who could pitch this so much better than I could locally.
Great. So I'll take the first one first, which is, it's funny, this work really grew out of something called community rights in South Central Pennsylvania way back in the late 1990s. So Republican, conservative, non-liberal, non-progressive communities that began to say no to factory hog farms coming into South Central Pennsylvania. That's where a lot of this work started, was asking the question of why communities don't have the power to veto these kinds of things. So the law in the United States today is when the federal or state government issues a permit, that the municipality is legally prohibited from banning the use that was recognized by the permit. So the question was, how do we find a new system of law, a new kind of, in some ways, refinding an older system of law that recognized this right of local community self-government, and how do we build laws on top of that? So I think some political encoding is probably is going to happen just because it's environmental protection. But I was amazed in Orange County, Florida. We got stories of Trump supporters having vote yes on this charter amendment in their window signs, because clean water kind of transcends those boundaries. And I think it is very much an issue important to Homo sapiens. Doesn't matter what end of the legal, political spectrum you're on. And I think there are ways to talk about it. I think there are genesis when it starts in a particular community. It's important that it start correctly with the right people, because otherwise it does very rapidly go into that political encoding place. So I think we do as much as we can to prevent that from happening by using universal language about clean water, and that this is what all this is tied to. And the failure of the existing system also gets you converts. When you talk about local control, a lot of this is about saying, okay, that pipeline that you want to put in through our community, we're going to say no to, because it's going to violate the right of the James River or violate the right of this river. And so we're going to take a stand against that. So I think that's a conventional Republican value, this local control kind of thing. And on your second question about what can we do, I mean, that's kind of why we're here, not just today, but overall. If there are two ways to run laws within communities. One is through your elected officials, which is the easiest thing, is to find somebody that's a convert or an advocate and run it that way. But these laws tend to not run through elected officials. They tend to have to be forced through citizen initiative processes, which are through ballot petitions to actually directly access the ballot in a popular vote to be voted on. In Orange County, they didn't quite go through that ballot petition process, but it was a popular vote that was taken. So you can either do it through the governmental processes that already exist, which is a difficult row to hoe because most of those municipal governments are not set up to do this kind of lawmaking, or do it directly through the community lawmaking process, which ends you on the ballot, then running a full-blown campaign, and then going over the heads of the elected officials at the city council level to actually put this law in place and enforce it. So those are the basic routes.
How do we start, Tom? Where do we?
The first starting point for communities that want to do this is to get a group of people together and then do a training similar to this, or watch one of the webinars to get a basic level understanding of what rights of nature means. And it's also, at least in my opinion, a bad place to start is talking about it in terms of rights of nature. That may sound weird, but people, when we use the word rights of nature as a phrase, it sounds very academic, kind of hippy-dippy-ish. And you really got to bring it down to the thing that you're trying to protect. So in Massachusetts, we have a group that's worked on protecting the Housatonic River. So they talk about the rights of the Housatonic. They don't talk about rights of nature as this all-encompassing broad theme. They say we're here to protect the river. And so we're going to talk about the rights of the Housatonic River. When you do that, you separate out that 30,000 level stuff from the reality of moving something on the ground, and you automatically get converts, whereas talking about something general like rights of nature generally loses people, or a lot of people. So getting a group together, getting in touch with us, the preliminary research that gets done by our campaign team about how to run something, like, is petition available in your state where you are, because all the laws are different? How do we do a petition? What's the timeline? What's the election we're aiming for? All that kind of stuff.
And I also want to chime in here and invite you, Zach, and everyone else on this call to join the Rights of Nature community on Hilo. The intention of that really is to help find these groups of people, and organize. And, maybe if there is enough momentum, we can organize additional Q&A sessions with Thomas. And yeah, it's open source, We'll never sell your data, unlike certain other big tech companies. And yeah, the intention really is to get those groups going. Yep, Kathleen, I will drop it right there. So you'll need to create an account before you can join. But yeah, we would love to see you there and start organizing together. And also, I know we're going to run out of time for questions. So it would also be a good place to kind of put those down and start building up our knowledge. So I see a question from David Ferreira.
Hey there. Yeah, Thomas, I just thank you for your presentation. Thanks, everybody. I was really curious about your characterization of environmental laws historically and how you distinguish them once the rights of nature example at the Tamunkwa borough came into being. I wrote that question in the chat at 12:48. You can find it.
Yeah, it's a great question. It usually exceeds the scope of some of these early webinars where we just try to talk about the concept, basic concept. But the answer lies in a law review article that we wrote, which we're happy to send to you. It was published a couple of years ago. It talks about the right of local community self-government as a constitutional right. That part of the work here, and the reason why democratic as well as environmental rights are included in our name, is that getting rights of nature laws to actually be enforced means expanding the portal of municipal lawmaking that currently exists. The system that we have in the United States makes municipalities like cities, towns, and villages completely subordinate to the state. And so we have to find a way to broaden the inherent powers of the municipality so that they enable a municipality to adopt heightened environmental standards beyond the state and federal standards that currently exist. So it gets very legalese in some of those places. But the basic understanding is that our communities should be able to pass laws that provide more stringent environmental standards. In other words, go above the floor of what's provided by the state and federal government, not go under that floor, but build on top of that floor to put in more stringent, heightened standing requirements for heightened protections for the natural environment. So we're happy to share that law review article, but it gets into the kind of the minutiae of how these, not just how the laws are passed, but how do you enforce them in a system that's openly hostile to them.
Thanks, David and Thomas. I see a raised hand from Donna Pepin.
Thanks. I know someone was asking about how to start groups, and I just wanted to say that the UU churches are very involved in the environment, and in DeLand we had an environmental committee here that has broadened out into bringing in action, and that's how I got involved in all the knowledge of the rights of nature and what's going on. So I know on a big platform, the UU Church is very involved. So it might be a start for someone if they don't have any other people that they could gather with. They have a lot of resources. We're lucky enough to have Jim DeRocher in our group, who's the representative of rights of nature for Flagler and I think Volusia County. So he's the one who told me about this so I could join in. But it's important to have a support group. I thank you so much for all the information. I'm learning a lot today.
Yeah, Jim is great. I went canoeing. I had the opportunity to go canoeing with him when I was last in Florida. And he showed me the sites of how badly some of these places have degraded. So one thing we don't want to leave people with is the idea that this is easy to do, because it's not. This is very difficult work, and all the very important people from lawyers to law professors will tell you that you can't do what you're trying to do. I'm convinced that within the next 10 or 15 years, this will be the dominant environmental protection trend in the United States. This is it. And I think we're seeing the beginnings of that now, these growth pains. But it's not easy to do. The existing system of law is set up not to let you do it. So you need a certain kind of DNA. We look for like a gene within people. They have to be people that don't care what other people think necessarily, especially very important people, but who are willing to move forward anyway because they understand that the status quo is not working. That if we're going to have a planet left to live on over the next 50 years, that we have to change how the law is applied to nature to protect it. And so it's good to get together with people, good to find those people, but sometimes finding them it takes a little while to do so.
Well, one more thing is, one thing I noticed, I was really active in I'm in a county that votes red, and like Orange County too. And I was amazed that even though the Republicans on their slate card said to vote against Echo and Forever, which were environmental programs, that through enough education, Volusia County voted it in, which that gives us 20 years. Echo and Forever in Volusia County are programs that help the environment and also things like bike paths. But even though it was on, a lot of representatives, Republicans got in, but on local issues, a lot of Democrats that were in neutral races got in through education. And I think environment, you're right, it's not a Democrat-Republican thing. There are lots of Republicans that feel strongly about the environment. And so getting Democrats and Republicans together on this issue helped us in Volusia County to pass the Echo and Forever. And of course, in Orange County, helped them to pass the rights of nature. So if you stay focused on that, and what I did when I saw Republicans get the slate card from people at the polls, I went up to them and I asked them, can I talk to you about these candidates? And they happen to be Democrats, but they were nonpartisan and the Echo and Forever. And lots of people were very responsive. And I know that's through me and other people, that's what got people to vote for things that their party didn't align with.
Yes, absolutely. And I think it's not a hyperbole to say that Florida has now put itself in a position of a leader in the rights of nature movement in the United States because of what happened in Orange County and what's happening now in other communities that are beginning to move forward with similar laws.
Thank you, Donna, for your question. Thank you, Thomas. I'm looking at the time and I know we are a little bit over now. So I want to be sensitive to those of us who might need to run off. Thomas, I don't know if you have a few more minutes, if you want to take more questions or if we should start wrapping it up.
Sure. Yeah, I'm good for another 5 minutes or so.
Okay, great. So it seems like we can take at least one more. But before we do that, I just want to drop a link to a survey in the chat. If you can fill it out, I'll also send it out via email. That would kind of help us understand, how we can organize in the future and move this forward. Let me drop that here. And let's hear from Grant Gelhardt. I think you had your hand up first. Sorry, Kyle, you'll be next. Grant, are you with us? Grant Gelhardt?
There, now can you hear me? Yes,
we can hear you. Yes, thank you.
Okay. I was wondering when a case is finally taken to court and argued, how would a rights of nature or an inanimate object, which is property, fare in the legal system that we are in right now, which only really recognizes people as the ability to take to court? I understand the indigenous rights issue, but our court system is set up under English common law.
Yes, that's absolutely correct. And English common law treats nature as a thing or as property. And that's what we talked about earlier. So, but you asked about very specific instances of enforcement. In the US, there have been very few of those. But keeping in mind that the laws themselves define that people or residents of communities can stand in the shoes of those ecosystems as guardians or trustees, basically, to bring the claim on behalf of the river. Because of course the river can't speak for itself, at least in English. It speaks for itself all the time in other ways. But that people can serve as a guardian or trustee for that ecosystem to make the claim. And it's not so much different than a guardian or trustee for a person, a child. So under the system of law that we have, when we try to determine the best interests of the child for various things like custody hearings, there will be someone assigned to essentially be a guardian ad litem or ad litem for that individual child. So we have plenty of examples of this kind of relationship that exists in the law today. The hope is to piggyback on those examples for these laws to be effective and to be implemented.
Is there any opportunity from looking of have gone to trial?
Grant, you're breaking up. I can't understand the question. I think we lost Grant.
Yeah, it was getting choppy for me too. Grant, I'm going to mute you for now and transition to Kyle, but you can let us know if you're back. Kyle?
Hello, can you hear me?
Yep, we can hear you.
Thank you, Shen Shen, for hosting this event, and thank you, Thomas Linzey. What an amazing presentation. I've heard of this over the years, here and there, most recently about what's happening in New Zealand with the Wangana, I'm not going to get it right, the river there being formally recognized as a person by the New Zealand government. This is after 148 years of lobbying by the Maoris. So it is an indigenous convergence with the national government. My question is, I've been tracking what's happening with blockchain and cryptocurrency, and it's also a tool that's being used by the Regen Network to help farmers transition to more ecological practices and document it and get paid for doing so, and so on. Is there, and Shay, thank you for answering this question already, but are you aware of groups that are taking a lead on developing tools using blockchain and related regenerative technologies to accelerate this process? I know Hilo is a good tool to organize, but are there other tools that are out there where we can create real synergies, especially as the old economy is collapsing and we hope a new one is emerging?
Yeah, unfortunately, probably outside of my ambit, whenever anything comes up on blockchain, I have to call somebody to actually ask them the question. But I think all areas are fertile and ripe for this kind of stuff. It's just that we don't work in that particular area, but I think it's probably a fertile one to look at.
And I do see a comment from Shay Howell in the chat that talks about Namibia having a link between blockchain and the rights of nature.
Yes, I'll have a look for sure. Thank you. Thank you, Shay.
And I just want to say that I also share that inquiry of wanting to know how we might leverage that technology and start, valuing nature, right? Like I hate to kind of apply that sort of frame to it, but I think it is going to help. It's a tool. It doesn't necessarily reflect reality, right? But it's a tool.
Sure.
All right. Well, I think that wraps it up for the questions. Thank you so much to Thomas for being here, for providing this amazing information, for fielding all these questions and going a little bit over. I will save this chat and try to send out the links to that people dropped in there. And in the follow-up email, I'll also include the survey. I can include links to, the Center for Democratic and Environmental Rights, to Terran Collective, to WU projects. And I'll also include the Hilo community link, I don't mean to make it sound like a shameless plug, but I really want to get this momentum harnessed and move forward with this. It's going to take, a whole village to do so. So with that, if there are no more final questions, I will wrap it up and say thank you to all for working to make this world a better place.
Thank you, everybody.
Thank you, everyone. Have a great day.